Good evening. This is the third part of the constitutional rights of the workers, which are anchored on our fundamental law of the land, particularly the 1987 Constitution. I will now be discussing to you the self-executing provisions of the 1987 Constitutions relating to labor. And these are provided under the Bill of Rights, Article 3, Sections 1, 4, 8, 10, 11, and 18, particularly Paragraph 2 of the 1987 Constitution. Let's go one by one. Article 3, Section 1 provides, "No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied equal protection of the laws." Well, our concentration, considering that we discuss labor, is on the property. We have the rights, like rights to life and liberty. Well, we dispense that. Considering that we discuss labor, we concentrate more on the property. And we know that employment is considered a property. So, since it is protected by our Constitution, it cannot be deprived also the worker without due process. The due process that we're talking about here is, of course, on both procedural and substantive due process. No person can be terminated or imposed a penalty or sanctions like demotions, like demerit of any employee without undergoing the both substantive and procedural due process of law. To continue, of course, the person shall likewise not be denied of the equal protection. Well, for workers similarly situated, okay, they should be given the same or substantially the same salaries, wages, and benefits or other emoluments relating to the respective employment. There shall be no discrimination among them, because if that's be the case, then this right of equal protection is likewise violated. The second right under the Constitution is, of course, under Section 4 of the Article 3, which provides that no person shall be passed abridging the freedom of speech, of expression, or of the press, and the right of the people peaceably to assemble and petition the government for redress of grievances. Well, any employee, even individually or collectively, whether they form an association or organization or in their own right, can, of course, air the grievances not only to the employer but even the government, provided that they do not act subversively, they do not commit any act constituting an act of terrorism or anything which they or may commit a crime, so long as they impose their basic rights as a worker, even petitioning the government for any grievances that they may have against the employer or against the government, especially in the imposition of wage order. Then they can do that, because these are enshrined in the Constitution. Article 3, Section 8 of the 1987 Constitution provides that the right of the people, including those employed in the public and private sectors, and the right to form association, unions, or societies for purposes not contrary to law shall not be abridged. So what is this right for? So anybody, even individually, or they collect among themselves, so long as they have mutuality of interest or commonality of interest, they can form a labor organization of their own choice, provided the purpose of this organization is to at least bargain their respective rights with the employer. So they cannot be charged for illegal association, illegal activities, or a crime for forming an organization, because this is also enshrined under the Bill of Rights, which is a self-executing provision of the 1987 Constitution. The next right is the Article 3, Section 10 of the 1987 Constitution, which provides that no law impairing the obligations of contract shall be impaired. What is this means? Well, for example, if the worker formed together with the other group of employees with the commonality of interest, form an association or union, and as a result, they forge a collective bargaining agreement. This collective bargaining agreement, which they forge with the employer concerning their rights, terms, conditions, and benefits of employment, it should be effective. It has the effect and force of law between the employer and the workers concerned, or the workers under this collective bargaining agreement. And even the Congress cannot pass a law declaring this collective bargaining agreement illegal or not in accordance with law, because this collective bargaining agreement, once forged, has the effect and force of right between the parties. Or the Congress cannot enact a law that prohibits the workers from joining, forming, or assisting a labor organization of their own choice. Well, this is applicable especially in the private sector. But in the government sector, well, there are some restrictions which the Constitution also provides. Another right is the accessibility to quasi-judicial bodies, particularly stated under Article 3, Section 11 of the 1987 Constitution, which states free access to courts and to quasi-judicial bodies shall not be abridged, or even adequate legal assistance to any person shall not be abridged solely by reason of poverty. What do you mean by that? Well, if a worker is, I can say, illegally dismissed from service, can he go to the forum where he can air his or her grievances? Yes. Like we have this constituted Court of Industrial Relations. Now we call it the National Labor Relations Commission, where this employee, even without bringing any pen, ball pen, or a coupon band, just go to a kiosk center and he is free to file a complaint against the erring employer. And not even a single centavo will he pay for such complaint. He or she will be assisted by a kiosk officer of the National Labor Relations Commission without collecting any fee from him. And even though this person would like to appeal the decision of the court or the labor of origin where the case was decided at first instance, in the Labor Arbitration Branch, can he appeal that to the National Labor Relations Commission for free? Yes. And if he or she is assisted by a public attorney, he is not required to pay a docket or appeal fee. Although, when he will be assisted by a counsel de parte or a paying lawyer, well, NLRC can only collect around 500 pesos for appeal fee and 50 pesos for the I believe for the other expenses relating to the appeal. So it's only around 550 pesos if the aggrieved employee will appeal his or her case from labor arbiter to the National Labor Relations Commission. Okay. Another right enshrined in Article 3, Section 18, Paragraph 2 of the 1987 Constitution. No involuntary servitude in any form shall exist except for a punishment of a crime whereof the party shall have been convicted. So what this is provision means to a laborer or to a worker? Well, a worker cannot be compelled to work under debt bondage. Meaning, if the worker is indebted to the employer for so much money, okay, the employer cannot contain him to work for him until he offset legally all his indebtedness. Or even his family cannot be contained by the employer if the employee cannot pay his debts to the employee. Or if the employee does not want any more in the with the company because of the unbearable treatment given by him, by the employer or the duly authorized representative, he cannot be detained by the employer by that reason. The employee can resign at any time, especially if there's an unbearable treatment committed by the employer against the person of the employee or any of the relatives. He can resign outright. Well, if there is no violation, the employee just resign on his own volition, he or she may be contained for a while, but it should not exceed 30 days. I hope you learned something in my own little way of discussing in substance the self-executing provisions of the Labor Code, particularly in the Bill of Rights. You will learn more, especially when we discuss the nitty-gritty aspect of the Labor Code of the Philippines. Thank you very much again.